I believe I just got the thumbs up to go ahead. Just checking in with my colleagues, Susan and Jared. Can you hear me? Amazing. Thank you. Hello and welcome, everyone. Just really quickly, my name is Gina Puntil. I use the pronoun she and her, and with my Tagalog-speaking family, siya. I'm zooming in from Treaty 6 territory, which is also a part of the Métis Nation of Alberta Region 4. More specifically, I'm on a Miskwichi land that has been colonially claimed as Edmonton, Alberta. I appreciate the opportunity that the Alberta Federation of Labour has given me to do a land acknowledgement, as it allows me to reflect on these treaties, these agreements, these contracts between Indigenous and non-Indigenous treaty people, to remember Canadian history, the celebrations, the failures, the harm, and also stand where I am right now, overwhelmed by people around me saying they want to do better. To acknowledge the land, either publicly or privately, as a proud Filipino Canadian and first generation born in Canada, I continue to evaluate my responsibility to these treaties, my responsibilities as a non-Indigenous settler, and my responsibility to the land that I have the privilege to live, play, and work on. And part of my job, one of my favorite parts of my job, is to engage in conversation with workers regarding health and safety in the workplace. And the Alberta Federation of Labour has provided a platform for us to be able to do that here. My daytime job is that I work with the Alberta Workers Health Centre and run a program that is targeted and speaks to teen-aged workers and new workers in Alberta. Questions of, can my boss do that? Or is that illegal? How can I keep myself safe at work? How can I keep my parents safe at work? If you're new at work, how can you bring up an issue like, and if you feel like you might lose your job? Education is key. So first, I want to thank you for taking the time tonight to join in on this session. The session so cleverly named Bill 47, what it means for your work, for your safety at work. And the good people to answer that question are Susan Cake. Just introduce yourself, starting with you, Susan.
Apologies, it's just my internet is a little shaky, so I'm just going to turn my video off. So my name is Susan Cake, and my pronouns are they, them, and I am the Director of Policy Analysis at the Alberta Federation of Labour. So one of the files that I cover is Occupational Health and Safety, and so I'm really excited to kind of dive into some of the changes that will be impacting workers.
Figuring that out, I just want to list off two things, or a couple of things. One, this session is being recorded, so just know that there will be access to this later on. And another is there will be time for questions at the end, but if questions do pop into your head, feel free to pop them into the Q&A section, which is at the bottom of your screen. If you're on a desktop or a laptop, it says Q&A. You can click on that. You have the option to answer with your name or anonymously. And I'm seeing in the chat that people can hear Susan and I cannot.
I think it's just people heard my intro and they're good to go.
Jared, are we able to hear you?
Hello, can you hear me? Yeah, so maybe this is... Susan, can you hear me?
I can hear Jared, I can hear Gina, and I think people can hear me. So I think that it's working.
Okay. Well, okay, so let's assume, for now anyway, that we can be heard. My name is Jared Matsunaga-Turnbull, he, him, and I am with the Alberta Workers Health Centre, and I'm happy to be here to sort of talk about a little bit about what our current health and safety legislation is, so that we get sort of an understanding before we move into what the significance, or what the specifics are, and what the significances are of the changes to the legislation. Susan, did you want to maybe talk a little bit about what the heck Bill 47 even is, while we're gathered here?
Sure, I'll start with that. So Bill 47 is an omnibus bill that affects occupational health and safety along with workers' compensation, and a different package called the Hero Compensation Fund. So today we're just going to focus on the occupational health and safety part because it's very large. The entire bill is really large and it'd be a lot to go through. And each of the areas deserves its own space to kind of explore and learn more about. And one of the things that we always have to keep in mind is the context that we're operating in right now. So we are obviously living through a global health pandemic. We are in the midst of it. There's really no sign that it's getting much better in Alberta. Oh, Gina's going to come back in later. Okay, be sure to make her a panelist. So there's really no sign that it's getting much better as we see our politicians enacting more restrictions to try to curb the growth and make sure that our hospitals do not become, we'll try to ensure that our hospitals do not become overwhelmed. So we have to be making really hard decisions about who will get treatment and who won't. So it's a very precarious time. And what we know historically about precarious times is that workers' health and safety is often put on the back burner. Not just during precarious financial times, but also when we're having a lot of things change in our society in a very rapid way. Welcome back, Gina. And so you always have to remember that the government did consultations on this, and they started the process for changing occupational health and safety and workers' compensation during the summer of a global health pandemic for 1 month. Approximately where the consultation was opened. It was not advertised widely, although it was publicly available. And I think there was a brief consultation further for select individuals on the occupational health and safety front. And now we have the legislation in front of us.
So I'm going to attempt to share my screen here and just sort of talk about, I don't know, these are weird, these webinar things, right? It'd be great if we were all in the room together and just be able to talk about things and see each other's faces. So it does seem a little bit like there's experts who are presenting information that we know everything about and others. And I kind of resist that. I think that some of us have some experience, but a lot of folks, and especially workers, are not given the credit that that is due about what health and safety is, because it has a direct impact in your everyday working lives and around your families, right? So I just say that I'm going to share some stuff just so that we're all on the same page, so we can understand the significance of some of these changes. And if I can, figure out the tech here, I'm going to share. Here we go. You can't see, but I'm doing amazing things with my mouse clicking on things right now. Okay. When we talk about occupational health and safety or workplace health and safety, OHS is kind of the acronym, so Occupational Health and Safety Law. In Alberta, most workers are covered under provincial legislation, under something called the Alberta OHS Act Regulations and Code. I don't know if you can see that blue book. If you have a screen in front of you, there's a blue book that actually should be available to every worker, and so you should have seen it by law. But we know the reality is that not many people do, right? So most workers are covered under provincial legislation, and that's what we're going to be talking about when it comes to Bill 47. Those are the changes we're talking about. Some workers are covered under another piece of legislation called the Canada Labour Code Part 2, and that's if you're what's called federally regulated. So bankers, some international or interprovincial trucking. There's a few other industries specifically that are under federal legislation. Postal workers, things like that, right? Federal government employees. The purpose of occupational health and safety law, regardless of which one you're covered under, is to prevent worksite incidents, injuries, illnesses, and diseases. And we should be careful that we're saying these are the minimum standards for health and safety compliance, what's called compliance, so adhering to the law. So these minimum standards are really important, but just like we understand that minimum wage is not necessarily a living wage, the minimum standards here of occupational health and safety law should be seen as just that, the minimums. And we should always be working, I think, as health and safety advocates and activists, pushing to get things better than those minimum standards, right? And workers with a union may have additional protection and processes in your collective bargaining agreement. So you should get to know that too, right? So you can't have standards that are below the minimum set out in law, but you can have additional things in your collective agreement. So occupational health and safety law is based on something called the Internal Responsibility System, or IRS. And it's based on this illustration here is like 3 pillars for it to work, right? Employer commitment to health and safety, worker participation in making your workplace safer, and government enforcement. So that if any of those, if the compliance doesn't happen, government can come in and make sure that workers are protected. So that's the ideal of what OHS law is based on. And it means that there are certain responsibilities for what we call workplace parties. So employers, the responsibilities to ensure the health and safety of workers and others at the worksite. For workers, we have to follow the health and safety rules and report health and safety concerns. And the government has the responsibility to administer and to enforce the law. So that's the responsibility that we may be some criticism around just how effective that is for some workers. So the internal responsibility system is another way of looking at it. So we'd looked at that like those 3-pillar kind of model, but this might be better to illustrate what actually happens in a workplace. So it's based on a self-regulation model where every individual is responsible for health and safety. You've probably heard that, right? Like we're all in this together. Health and safety is everyone's responsibility. It also assumes that every individual is able and free to raise a health and safety concern and report an unsafe condition. Right. So if you look at this illustration here, for those of you who can see your screen, basically you've got employers, workers, and government. But and though the idea is that we're all equal players in this, and especially in the workplace, employers and workers have equal responsibility. It's actually not the truth, right? It ignores that there is a power imbalance, that employers have the bulk of the power to introduce new hazards and new processes into the workplace. They have the power to discipline, hire and fire. And the law is actually set up to acknowledge this in some way, and by making sure that employers have the bulk of the responsibility to actually create a healthy and safe workplace. And so there's this teeter-totter image here where we have employers having the bulk of power, workers, an individual worker in particular, not having a lot of power. And that government on the side, there's actually a responsibility for the government to know that, it actually takes enforcement. It takes making sure that administration of the law is robust to afford workers more power, acknowledging that power is really imbalanced in the workplace. So I hope that makes sense. So it's a visual way that I think is helpful to understand it. So because of this, the law actually acknowledges there is a slight power imbalance and enshrines what's called our 4 basic health and safety rights, if that makes sense. The right to know about the dangers of our jobs and how we're protected, the right to participate and meaningfully participate in health and safety discussions and actions in our workplace, the right to refuse dangerous work, and the right to be free from reprisal, the right to be free from being punished for using any of those other rights. So these are really key, and I think it's one thing to say that the law actually says, yes, you've got all these rights, and the employer is then responsible for making sure that these rights are afforded to workers and carried out. But how those rights, how workers are able to actually act on those rights can be different, right? There needs to be some specifics laid out, and that's what's one of the changes that Susan's going to talk about. I just want to quickly talk about worker participation and why it's important. Workers and employers not only just having different power, but workers and employers may have different goals, right? You can be the best employer in the world, right? And the kind-heartedest, but there's always going to be that sort of profitability or efficiency thing because of the role that you're wearing, right? So that might be your goal. Whereas a worker, we really want to, we want to do our job. We want to do our job well. And we want to make sure that we get home as started to get to work, right? Employers have the power, like I said, to introduce new materials and processes into the workplace. So because of that, and even if an employer introduces something they don't know is a hazard, but turns out to be a hazard, there needs to be checks and balances. And the best way to do that is to make sure that workers are involved in the process and participating in questioning what these new things are being introduced into the workplace are. So the other thing is that under the internal responsibility system, the way that OHS law is framed, government enforcement usually requires a complaint from someone, It's usually not an employer that files a complaint, so it has to be a worker that feels like they have the ability to file a complaint, or an incident has to happen. An incident means someone has been killed, someone has been seriously hurt, or someone has almost had what's called a near miss, or a potentially serious incident where that triggers some enforcement actions and inspections. And these are important, but it also means that you need to have things spelled out so to enable complaints and inspections to happen. So hopefully that makes sense. I think that's where I'm going to leave it. That's kind of the goal of OHS, how it's set up. And Susan, maybe you can talk about what's happening now. I'm going to stop sharing here.
Okay, so now I'm just going to cover broadly what some of the changes have been. There we go. Because the bill was an entirely new bill, which is slightly different than what you'll see with some other legislation where they will change aspects of a bill. This is an entire rewrite, reorganization. So there's a lot of change in this. And I'm going to go over just some of the highlights of it around the various rights that Jared had discussed. So the first one I want to touch on is the right to know. And so of the 4 rights, this right is fundamental in order for you to have any other rights as a worker, because if you don't know, if you don't have the information about hazards in your workplace, it's really hard to meaningfully participate in an occupational health and safety program. It's really hard to refuse unsafe work when you're not entirely sure something you're doing is unsafe. And it's hard to implement any of those rights if you don't have the foundation of knowledge. So I've divided this slide out into 2018, 2020. So this is just what the legislation basically said before and what it says now. And so there's a lot of changes around information and how a worker can get information on a work site. One of the most obvious is the 2020, so the new legislation, it doesn't require the posting of names for occupational health and safety committees. And this is a big thing because it means you don't know who on your work site is your worker rep that's responsible for making sure worker concerns are heard by the employer in a joint committee setting. So it'll still exist in some capacity for most work sites, but you won't necessarily know who's on it. One of the other things was just the flow of information changed dramatically. So before, with the flow of information, most worksite parties had an obligation that if they found a new hazard, and this is especially important for work sites that have multi-employers, if they found a new hazard or somebody came across it, basically you had to tell everybody on the work site, every party. And it was to ensure that information was always flowing in back and forth so that everyone was aware of what was going on. Now, the way the information flows is there's certain worksite parties that only have to tell certain worksite parties, and then those worksite parties have to tell other worksite parties. So you kind of have this chain that information has to go down. And that means that if there's any break in the chain or somebody doesn't get this right, or perhaps they don't inform people in a timely manner, you have a lot of misinformation and people missing information that may be really important for their job. There were some other changes as well with the 2020 legal changes around the information that employers have to actually keep on hand. Now, these are slight word changes and slight changes in definition, but really what they do is water down the legislation on a whole, that employers will have to keep less detailed information about less things or less hazards on the work site. And just it's far less robust and there's far less specificity. And when we don't have those details, it can be easy to leave things out. So overall, we're seeing less information being provided to workers. One of the other aspects about the right to know is something called exemptions. And so you can get this was previously available, and this also speaks to one of the questions that was actually already in our Q&A of can unions negotiate below the OH&S floor? So one of the things that employers have been allowed to do for a while now is they can apply for an exemption from a part of the OH&S Act, whether it's an exemption for certain equipment or practice or having a certain professional on a work site, you're allowed to apply. And so there's ways that you can go about it. Originally, in the old legislation, if any employer made an application, workers had to be consulted that would be affected. So if your employer wanted to bring in a different form of a personal protective equipment, say it's a different type of mask than the one that was already approved in Alberta, they would have to consult you. The government would, and they'd have to make sure that you are okay with this and that you are meaningfully engaged in it in some way. Now with the new legislation, there is no requirement for consultation whatsoever. So employers that choose not to tell their workforce that they're applying for an exemption under the OH&S Act wouldn't necessarily be aware that their employer has been granted one or not granted one by government. Under the previous legislation, any exemption also had to be equal or better than what was in the OH&S Act for Alberta. And now that has changed. So some exemptions have to be equal and better. Some, there's no requirement for that. And there's even one that simply says it must be suitable for the Alberta condition. And the Alberta condition is never defined. So that is a very subjective term, and we have no idea how it's going to be measured. And then one of the last things that I want to highlight with exemptions is that they used to be posted publicly so that everybody was aware when an employer had a certain exemption for how long the exemption was going to last and whatnot. And now there's no requirement to be posting this publicly. So this is just one other aspect of workers having less information about the hazards and the protections on their worksite. So the right to participate, I'm just going to focus on the joint health and safety committees that we've seen on worksites. And these were brought in 2018. They historically have been in most jurisdictions in Canada, if not all of them. And a lot of the research around this is really good because we find that they do make worksites safer when they're functioning committees. And what it does allow is one of the things that Jared touched on is that workers have a great depth of knowledge about the hazards they face on their worksite, often because they're dealing with it day in and day out. And so they have this great knowledge and they can look at employers' safety programs and really tell them if it's going to make an impact and if it's going to be a positive impact, because they can evaluate it from the worker's perspective. And so these joint committees really help with that. And it's a key part of participation. So now the new changes have created different obligations for different worksite parties. And so certain worksites that are over 20 people will not be required to have occupational health and safety committees for workers and employers. That's no longer a requirement for some. The regulation is still if you regularly employ 20 people or more, you need to have one. But it becomes a lot different on multi-employer worksites. And those are where we're seeing the UCP essentially say that those work sites do not need occupational health and safety committees if they have a prime contractor. One of the other things that they took out was mandatory training. And so it's really important for members of the committee to be trained in what they do and also to be able to update their occupational health and safety knowledge with the development of the field. And so as we get growing medical evidence, we want to know these links between worksites, injuries and diseases and different practices or chemicals that people may be exposed to, for example. And now we don't see any explicit details around that training. It's also really unclear now how worker representatives will be selected for these committees, especially when there is no union. So like in the older legislation, the workers had to select their representative in some democratic capacity. It is a way of ensuring that it was actually a worker representative. Now the Act is silent on that. And so the implication may be that an employer can handpick a worker to be on such committee, which really calls into question if that employee is actually representing workers and who they're accountable to. And then lastly, a lot of the detail has been taken out in this section of the Act for what the committee is actually going to do and what it's responsible for. One of the notable things that was taken out is that the committee used to review an employer's occupational health and safety program for effectiveness. So really looking at if it is a value and if it's working, and that has been taken out. The UCP has made statements that they plan on putting these into the code, but that is inconsistent with what they've done with other legislation. They've also made promises that they would add things or change them, and they haven't come to fruition. So it's really difficult to kind of put your faith that they're going to put this in the code when that hasn't been what they've done in the past. So the next right is just the right to refuse unsafe work. And so this has drastically been altered. One of the first things is what is unsafe work? Before it was a worker's honest belief of danger. A lot of the weight for this was put on the worker knowing what was going to be a danger for them and having an honest belief that what the work they were being asked to do was going to be dangerous. Now we have 3 hurdles we essentially need to get through for a worker to actually refuse unsafe work. The first is that it has to be an undue hazard. And this brings up the implication of what is a hazard that is allowable versus one that's not allowable. What exactly is undue? And it really normalizes that certain hazards are just normal and that you just have to deal with it regardless of how it's mitigated in the workplace by various controls or work processes. And then the second one is that the threat has to be immediate. And this calls into question, is that rock going to fall now, or is it going to fall in a month or two? And then what is immediacy when it comes to danger? And then the third part is serious. And so this leaves open the door that maybe if it's an injury that's not considered serious, you can't refuse unsafe work when it comes to it. So it brings 3 new hurdles essentially in. There's also changes for how it's investigated. So previously, a work refusal for unsafe work would be investigated with that worker, with the employer, with a member of the Occupational Health and Safety Committee, or if they're not available, another worker that the worker has chosen. And it's really to make it less of an isolation, so you're not turning into like a argument with your boss over who's right. That's all gone now, and the employer is alone to investigate and determine if the work is unsafe. And then this brings it forward issues in the next step, which is notifying other workers who may be assigned to that work. And so there's a chance now that a worker can be assigned to work that another worker has refused for being unsafe, and they would not be notified that another worker has done that, which really puts them at risk. So you can imagine a scenario where an older worker who really knows the job site in and out, knows the work, recognizes something is dangerous. And now you can have a situation where a new worker may not, and then may continue doing that dangerous work task. And there's a few other changes, especially the protections around wages and benefits are much more loose in this capacity. And it does appear that if a worker refuses unsafe work and there is no other work at a similar pay level that they could be assigned to, they could be sent home, which essentially means that they would be punished with no wages if they refuse unsafe work. And so the last right I'm going to talk about is the right to be free from reprisal, which is basically the right not to be punished for doing something under the Occupational Health and Safety Act and Code. And so we really see that the UCP has watered down these significantly. So for instance, in the work refusal, there's no longer protections. The language took out any protections of benefits. And then there's only certain protections for wages if the employer has other work for you to do if you refuse unsafe work, which obviously seems like a punishment to be sent home because the work is unsafe. And then there's also changes for, prior to this, it was called, hi.
You're back. Okay, great. We did lose you a bit on the last slide. I was wondering if you would be able to take it back a bit, my friend.
I definitely can. So did we hear the part about discriminatory and disciplinary? Okay, I'll start there. So they've changed the term discriminatory to disciplinary. And what this essentially does is that if a worker does anything under the Occupational Health and Safety Act, one of their various rights or one of their responsibilities, the idea is that the employer shouldn't be able to punish you for this. And so the wording change actually opens up a range of options that employers may use that we will now have to argue are actually disciplinary. And so what we've seen on certain work sites is workers will be assigned to work that is incredibly onerous or things that nobody else wants to do. They may be assigned to one specific shift, such as night shift. There's various ways that a worker can be punished now that are in this kind of gray area. So we're not entirely sure. And then the last change that we saw here that's pretty significant is that for a disciplinary action, so when a worker feels like they've been their employer has disciplined them for something, they can appeal this to an OH&S officer. And now the language has changed that if a worker is under collective bargaining agreement, that I'm just going to stop my video because it's that a worker is under a collective bargaining agreement, they can no longer go to an OH&S officer, and they have to go through their own collective bargaining agreement. And the main issue with this is that it often takes quite a long time for this to actually happen. And so it's usually, a closer to a year to work through the grievance process under most collective bargaining agreements. And right now they are booking arbitrations a year out from that. So workers who are under collective bargaining agreements who are punished for, exercising occupational health and safety right could then theoretically be fired and not be reinstated in their job for a year to year and a half to 2 years, where workers who are not under collective bargaining agreements would have their rights enforced by government and then just much more secure. So this is just a way of downloading the actual enforcement of this section of the OH&S Act onto unions instead of the government taking that role and responsibility, which is where it should be.
Susan, it's Jared. I noticed that we cut out during one section there. So maybe just for clarity's sake, what's happening is if there is a discriminatory or a disciplinary action and you want to file an appeal, if you belong to a union, you'd have to go through the grievance procedure of your union instead of going through what used to be a multiple sort of level approach to appeals through the OHS department, through a director, through officers, whatever that is, and then the Labor Relations Board, right? So yes. They've downloaded, like you're saying, they're downloading onto unions. Yeah.
Yes. And so if there's any specific questions, we can look at that in the Q&A section for people. But I'm going to just stop sharing my screen. There we go.
I am so sorry. I cannot hear a thing right now. So there's some questions in the Q&A, and I'm wondering if you might be able to address them.
If it helps, Gina, I can hear you. So if you want to, read the question or anything like that, that's absolutely fine.
So of course she didn't hear that, right? So this is the marvel of a webinar here. I'm going to suggest that we take the questions. I just wanted to add something in really quick that I was jamming on here about it's the right to participate. They frame this a lot, as Susan was saying, around increased flexibility for so-called job creators, right, or employers. To find out the best approach possible to and get outcomes, safety outcomes, without having a lot of prescription to it. And I think my concerns as a worker advocate are that prescription was actually what gave workers some sense of that there was a process, there was accountability, and there was things that were going to be reacted to, right? So the benefit of having prescription when it came down to the right to refuse and a process that says the Health and Safety Committee has to be involved. These are the steps that has to happen that the employer is responsible for fulfilling before a worker can go back to work or before a new worker can be assigned to a task. Without that level of prescription, workers are actually going to be put into danger, right? The other thing is when it comes to committees, the requirement to have regular inspections done by the committee is gone. And this is significant because the point of a committee is made up of, like you were saying, Susan, is workers being part of that process because we're the ones doing the work. And so if the ones doing the work aren't involved directly in what's happening in the workplace, first of all, I mean, you can talk about safety culture of a workplace. It's beneficial to have workers involved in that because everyone sort of follows suit. But as a check and balance, that is a critical part of making sure that your workplace is safe, is those regular inspections done by not just the employer, who has, in some cases, a vested interest in making sure everything is okay so they can get through the day, right? And the other thing would be that there used to be, I mean, there's arguments around the effectiveness of a committee anyway, right? The committee didn't have tons of power. The power was sitting in a room with other people and talking about it and actually raising health and safety concerns and putting it through a recommendation process that the employer then had to, within a 30-day time limit, say, I agree, this is a problem, we're going to fix it. And in the short term, this is what we're going to do. In the longer term, this is what we're going to do. Or they could say, I don't agree, in which case the committee could pull in an OHS officer, they could do an inspection, they could resubmit it for recommendation. Mm-hmm. New proposed legislation. Sorry, Susan, those are the things that
yes, absolutely. I mean, the bill it's so big and there's so many changes. And So anyways, let's get to questions. I've noticed a couple of people asking about if these PowerPoints will be available. And so we are recording this webinar, and basically when we record it, we record the section where the presentations happen, and we're not necessarily recording the Q&A. So you should feel free to ask questions and do what you want to do.
For a lot of people, workplace health and safety and workers' comp, it's not the top of mind for most people until something goes wrong. And for others, it might be a priority, but they're just struggling to get by. And so I think it's really important. And one of the things in terms of taking a look and seeing what kind of power do we each have as individuals, and then collectively to be able to raise a stink, raise our voice on behalf of those who, for various reasons, don't have the voice. And those are the people who are going to be most impacted by these changes, right? It's hard enough to use your right to refuse as it is for most people. And now you're making it even harder. It's shameful, I will say. And I think it becomes a good challenge for us to figure out how can we make this known, because it's fairly invisible, and then how we can work together to change it.
Okay. So on that note, we're going to wrap up the webinar. Thank you so much, everyone, for coming out. Thank you, Jared, and for offering your expertise. Thank you, Gina, for being our moderator. And thank you, technology, for sometimes supporting us and sometimes not, and making it a fun time to be on your toes. And thank you, everybody, for taking time out of your evening tonight to join us. And hopefully you can use this information, and we'll be in contact with you as a follow-up with some of the information that was in the webinar. And I hope everyone has a great night.
Thanks, everyone.
Bye, everyone.